Children born within the Virgin Islands are now entitled to equal status, as the Status of Children Act 2014 succeeded during the 5th sitting of the 3rd session of the 2nd House of Assembly on March 27, 2014. Today we divulge into what this new legislation now means for the welfare of our children and the people of these Virgin Islands. I'm your host, Adriana Salvaral, Information Officer reporting for the Ministry of Health and Social Development and the Department of Information and Public Relations. Joining me today is Gender Affairs Coordinator, Ms. Laura Lee Connor, and our legal team, Ms. Kamika Forbes of Forbes Hair and Mr. Jack Husbands of Walkers. Welcome to the program, and thank you all for joining me today. You're welcome. So let's just go into what the passing of this act now means. Maybe Mr. Husband, you can answer first.
Oh, okay. The mile goes first, I suppose. Now we're talking about gender and status of children. What it means is that the revolutionary thing about it abolishes the status of illegitimacy. So now all children will be of equal status. And a child's status, the inheritance and other things, would no longer be determined by whether his parents were married when he was born or she was born, or became married to one another subsequently. So the marital status of the parents has nothing to do with the status of the child. That's in a nutshell what it does.
So if Ms. Connor, can you divulge on how the Office of Gender Affairs plays a role in that equal status rights for the children?
Well, the Office of Gender Affairs is charged with promoting gender equality and equity through programs and policy. And with the passing of this act, it will be our responsibility then to inform the public, sensitize them on the equal status of children now as it pertains to this particular act.
Now, Ms. Forbes, can you just enlighten us on the difference between equal status and equal rights for the children?
I don't think, for the purposes of this act, that there's a real distinction between the two, equal status and equal rights. So I'm going to address the question in totality, and just to highlight what Jack has already stated. It does mean right now that in the BVI, the term illegitimate will now be removed from statute and from our laws, and it will not be recognized that we'll say that there's no distinction then between children, whether they're born in wedlock or outside of wedlock. What that means is that the rights of inheritance will then be distributed accordingly to all children, regardless of their parents. And I think Jack has covered this earlier.
How does this impact households or married couples?
Well, it shouldn't impact marriage, and I think that's what we need to make clear, is that this act is not directed to marriages or even couples. It's about children, and it's making sure that from the day a child is born, he or she will not be viewed any differently from any other child. That's the distinction. I should say here that even if you were a child born out of wedlock prior to the passing of this act, you will now gain that equal status as if you were born inside wedlock. So it's not about marriage and it's not about couples. It is really primarily based towards children and making sure that all of us as children, because we all are somebody's child, are on the same equal footing.
So a married man has children outside of his marriage, and he dies without a will. How will the act come into play?
Well, this goes back to what we were saying. Basically, before, when we have to look at the position before the passing of the act, what would happen is then that had this act not been enforced, children born outside of that man's marriage would not be entitled to any portion of his estate as of law. The act changes the position. What would happen now that we've had this act in place is that all of his children, regardless of whether or not they were born in the first marriage, in the second marriage, or outside of any of those marriages, would be equally entitled to the distribution of his estate. This is, of course, subject to whatever the widow is entitled to under the Intestate Estates Act.
Okay, so Mr. Husbands, if you can now elaborate, being a man, a lot of persons have the notion that the act will tell them how to distribute. So can you clarify that? Will this act tell persons how they should divide their income or divide whatever it is that they leave behind?
No, that view is misguided because the Act doesn't do anything about inheritance. All the Act says is that your children are your children, so all your children are entitled to share equally in your assets if you die without leaving a will. But it doesn't change anything. The law now says that if you die without a will, the children from a marriage, whether it was your first or second, once they were born in a marriage, those children will inherit your property. But the law now says that children who were born even outside of a marriage, or outside of a marriage where the two parents don't get married to one another subsequently, those children will now share. So it doesn't really change inheritance. It only creates an advantage or gives a right to the child born outside to share, on inheritance where no will is made. In some places, the law does specify what should be done in respect of children. It's called Inheritance Family Provisions Law, where the law says whether you left a will or not, your spouse should get so much of your estate. If you die leaving children who are mentally or physically under any mental or physical incapacity, they should get. So some places the law actually tells you who should get, even if you make a will, but that's not the case with this statute.
Okay, good to know that. Explain how the Act will benefit men in ensuring or establishing their rights as a parent.
It doesn't affect how men enforce or access their rights as parents. Discerning fathers would still have looked after their children anyhow, you hope, whether they were born within or outside of marriage. They're all the children. They have the same DNA. As if you had diabetes, your children inside and outside may be susceptible to it equally, whether they were born inside or outside of marriage. All it does is that it allows a man to, it allows the law now, without the man making any provision for those children, that the law says these are your children. I suppose it also allows a man to inherit the property of his children. If his child dies and the child is born outside of marriage, and the man may be elderly by then, and the child may be well off, so it benefits men in that sense, I suppose. Yeah.
Ms. Forbes, would you like to elaborate on that?
In addition to what Jack has said, I think one of the key provisions that's now in the law is the right of all men to have that status of joint legal guardian, regardless of whether or not they were married to the child's mother at the time. And what that does, what that means for the BVI is that all men in the BVI now can apply to the courts, whether it's for custody or even rights of access to their children, regardless of whether or not they were married to the child's mother. And I think that that's one of the key factors within the Act that men definitely should be grateful for. And I know I personally am excited that this has finally come into play within our society, because it's recognizing that, you know, children have two parents, and it's important that both parents be given equal rights.
That's very important, actually, because previous to this, a man who was not the marital, was not the father of the child, because he was not married to the mother, he was not considered the legitimate father, could not apply for maintenance, could not easily apply for a custody order. But this now would remove that. So any man, whether he's married to the mother or not, could put up a case and could have either joint arrangements or, in a certain case, sole custody as well.
Well, can you elaborate on other legislations that this Act will have an impact on or will amend? You can just give a highlight on some of them.
Well, there's the Magistrates Code of Procedure that has been working on currently, and we're also looking at testing paternity. The ministry is working on getting that established as well, so you can determine the paternity of a child.
Okay. In the House of Assembly, when it was being debated, a member brought the notion of the Act disrupting the sanctity of marriage. Is this true or false? And explain a little bit more detail. I know, Ms. Forbes, you touched on it, saying that it has nothing to do with marriages. But I know a lot of women in the community has come forward and said that, that this Act is not favored by them. So maybe, Ms. Connor, you can touch on it first, and then our legal team.
Well, I believe the Act speaks specifically to children, it has absolutely nothing to do with relationships. And I think if we can get the public to understand that this act is not about saving your marriage or destroying your marriage, it's about children who are born to a person. They will be recognized now as a child of that person and not legitimate or illegitimate, but a child of that person. And it gives that child the equal access to that person, as in visitation, contribution, etc., inheritance. I mean, we have to look at all of these things from a child perspective. That child didn't make themselves. That child was created by a man and a woman. And that child now has access to both that man and that woman. It has nothing to do with the relationship. If that man is married, then he should have known beforehand that this would cause a bit of disruption within his family.
Correct.
And it's not the child's fault.
And I will say that if you think about it, it doesn't trouble the rights of wives anyhow. Because let's assume a man and a husband or wife own a house. She owns one half and he owns one half. Well, if anything happens to him, if he dies, his one half goes to who the law says it should go to. It will go to his children and his wife. So that she's not losing anything because she still has her one half of the house. So it's just that his half is split up among all of his children and his wife if he doesn't make a will. So it's not really that she loses anything, or children who didn't build the house come and get it, because it's just going to his children. And it's only his share that goes to his children. So it's, in the typical case, there's nothing really to worry about.
Well, I'll have this question for the legal team. A lot of persons, you know, we watch television and we're exposed to a lot of laws and legislations that are not common here in the BVI. So that legislation about who owns what and what property goes to who, or prenuptial agreements, that type of things within marriages. Can you maybe just make it clear that here's not California, basically, or here is not like some laws maybe in the U.S. or Northern America?
I agree with you totally. Obviously, the laws in the BVI are specific to the BVI, and we shouldn't be easily swayed by what we see in other jurisdictions or in other areas of the world. If you have a doubt or a question about the law, what is applicable here, I would definitely recommend that you go and seek legal advice from a lawyer within the jurisdiction who can tell you what the position is. But certainly, as far as, you know, prenuptials and postnuptials, I won't get into that in this forum because I don't think it's directly related to the Status of Children Act. But it's not something that this act now tries to overthrow. What men and all persons should be concerned of at this point is that if you want to ensure that your estate is divided a certain way, make a will. Yes. That's the only way to go about it. You need to make a will and make provision. Therefore, you wouldn't have to run into, you know, the issue of whether or not children born outside should receive, because you would have said what you want to happen to your property.
Correct.
So, you know, that's what my advice would be to persons.
So I know we talked a lot about children, and we didn't really specify an age, and I know persons are very curious on, is there an age limit, or is a child is a child? Could maybe one of you elaborate on that definition?
Well, a child is a child. It's not that you have to be under 18 to take the benefit of this statute. A child meaning your offspring. So that if you are 80 years old and your child is 60, and he was born out of marriage, that child of yours, that offspring of yours, is now considered your child. So it doesn't mean that there's a cutoff date. It only applies to people under 18. Child means the offspring of a person, really.
How will this act affect a child's rights in the BVI and compare its obligations to international standards?
I think it probably brings it in. I don't know, Laura Lee.
I think the act will enlarge the rights of children formerly considered illegitimate. We just remove that from them because it's no longer acceptable. It's no longer right to call a child illegitimate, no matter what circumstances they were born into. So that will be removed. So that's why I'm saying this sort of forum where we can educate the public, sensitize, have discussion. We need to open dialogue so that concerns can be addressed, because it's an act to just give children rights at the end of the day. That's the bottom line.
Okay.
Yeah, I mean, used to be a stigma beforehand if there was a stigma to illegitimacy. For example, you could be baptized on the same day as the children who were born with the parents married.
Oh, wow.
I think they could be baptized on a Sunday, you have to be baptized on a Wednesday or something like that. So, and then there was a status to it. So, because you had no father, in a lot of cases, the father's name was not probably even on your birth certificate. So there was a blank space where there was father. So it removes that type of status. You don't have to carry that through your life anymore.
I think also, I mean, what's happening now with the passing of this legislation is that the BVI is coming on stream with a lot of its international counterparts. From our discussions, I mean, I certainly know, and I think Laurie was saying that we are one of the last Caribbean countries to come
English-speaking
Caribbean countries, sorry, to actually recognize that all children should be equal, have equal status.
Right. Can the mothers or a 10-year-old use this act now to take the father to court, maybe for child support?
I think even without the passing of this act, that was an avenue available to fathers before. But yes, mothers, sorry. But yes, they can use this act as well now to have the court make a declaration that he or she, that he is the father of the child. And that's something that's new also within the act, is that it allows, if a father has been acting as if they were the father of a child for X amount of years. There's never been any DNA testing. The court under this legislation can go ahead and make a declaration based on his behavior that he is in fact the father. And Mr. Husbands can correct me if I'm wrong, but previously it would normally be the court, so you'd go to the magistrate's court, and then if you want the birth certificate, then you would declare to be the putative father. And that's when the obligations of maintaining a child would be attracted, or if you obviously agree to do DNA testing, that would be something that...
Because you may have signed the child school reports in the place where it says parent or father. So if you've been signing the child school reports for years, all of that is evidence that could go to establish that you're the father.
Okay. Yeah. And then, say for instance, the father is deceased, and a young child born out of wedlock comes into play, their parent can go ahead and go to the courts.
They can, yes, as a legal guardian, they can apply to the courts for whatever provision they may need.
Okay, we've mentioned this word illegitimate and legitimate a lot, and inside and outside, and the stigmas about it. But legally, it will eradicate this term, or should we stop using it? A person should be afraid to say it. Like, tell us more about it, Ms. Connor, first.
Well, it's amazing that you're telling me to tell it because, or answer this question, because illegitimacy is no longer a term that we should use to children who are born outside of wedlock. Equality is what we're looking at with this act. Equality is what's established in this act. And we have to remember that children, as I said earlier, they didn't make themselves, they came into this situation. So society needs to now look at these children as just that, children.
Right.
Otherwise, you're what you call visiting the sins of the parents, if you call it that, on the children. The children, it's nothing to do with them. The fact is that they were born, and there's no reason why the fact that their parents were married, which they had nothing to do with, they should be of different status to somebody whose parents were married, and they had nothing to do with that either. So it is not really sensible anymore to distinguish between children on that basis. Used to be a rule too, for example, a lot of rules that went along to support this. If you made a will and referred to your children, that was deemed to mean your children born in your marriage, your legitimate children, and it excluded your illegitimate children. There used to be a presumption that children means legitimate children. Now those presumptions and so on will be abolished, so that whenever a reference is made to children, it's a reference to all your children.
Right.
Okay, thank you all for that. And now we'll have a short break. Stay tuned.
You spend quality time with me.
They are men who have answered a challenge and earned the respect of their community and their family. These men are not presidents, business titans, or religious leaders, nor are they fighters or soldiers. These men are simply fathers. In a world in which too many children feel that their fathers are distant, dominating, or closed off, you have a chance to be a father who cares deeply and compassionately for their family and for their community, and who has the courage to to show it.
You are my father.
This message has been brought to you by the Office of Gender Affairs. Welcome back to our program, and we've been discussing the Status of Children Act 2013, which was recently passed this year. My guest again is Ms. Laura Lee Connor, Gender Affairs Coordinator, and our legal team, Ms. Kamika Forbes and Mr. Jack Husbands. Now, I know we've been getting into it back and forth about illegitimacy and the status of children, equal rights, marriages, and so forth. And we'll just kind of wrap up a little bit. But for the sake of anyone who still has any queries about this act and how it will impact their families, with it passing, is it retroactive? Ms. Forbes.
Not in the sense that if an estate has already been distributed, that a child who was born outside and previously referred to as an illegitimate can now go ahead and challenge the estate. But it is retroactive in the sense that even if you were born prior to the passing of this act, your status would be the same as a child born within wedlock. So in essence, if the property has already been settled, you cannot go and interfere with it.
Right.
But if there's yet property to be distributed, or should I say probate to be, entered into, then you will have a change in your position as a child, regardless of your age.
Will wives have a say in the distributions of the husband's estate once a will is absent?
I think we need to be clear that even prior to the passing of the act, they didn't have a say. If there's no, and just make sure I heard you correctly. You said if there is a will,
the will is absent. No will.
They didn't have a say previously, because the property would have to be distributed in accordance with the BVI laws of on intestacy. So the act doesn't compromise a wife's position in any way. So no, they don't have a say now. They didn't have a say then. We all have to go according to what the law says, and it's very clear. The only difference is that now children born outside of this marriage would be entitled to an equal share as children within the marriage.
Yeah, I think I should add to that. Yes. Wives never had a strong position if the husband died without making a will anyhow, if he died intestate. Under the Intestate Estates Act, I think the wife is entitled to annuity of 10% of the value of the estate or something like that, and she's entitled to personal chattels, but she's not entitled to all of it or half of it or whatever. So the wife's position, even before, since the passing of the act, hasn't been strong. It's the children who have a probably stronger position.
Yeah.
That's good to know. I don't think I knew that. No, I didn't. And judging by Ms. Connor's face, I don't think that she was aware either.
Yeah, I didn't know that. 10%? That's really low. Oh,
well, we're here to discuss it, and I'm glad you're making it known to our public. So I just want to get into a few scenarios that we've gotten from the public via social media and just conversations. So Ms. Forbes, you mentioned it a little bit earlier. Say, for instance, a man and a woman, they're living together for years, they have children, the man is taking care of his family, financially supportive, and he dies without a will, they're not married. What will then happen without the act? What would happen without the act? And now that the act is in place, what will then happen?
Okay, before the act, then the children would be left out in the cold, and the his partner, unfortunately. There would have been no provision made for them out of that estate. The estate would have then gone to whether he had siblings or whatever the next step is within the Intestacy Act. But now that we have this act in place, that enables their children, his children, to benefit from the estate on his death. And I should say that once a man and a woman have been living together, I think the act specifies for about 3 years, and a child is born within 10 months of them, if they happen to separating, then that man is presumed to be the father of those children. So if a man and woman live together, they have children within that time that they're living together, and they've passed that 3-year threshold, then he's presumed to be the father anyway, without the DNA testing. This is what we spoke about earlier when we were talking about declarations being made had he acted as if he was the father. So that's a similar scenario that's brought in with this act as well.
There's another concern that, well, how will the act impact mothers, especially if maybe a woman has a child and she leaves the child with the father and runs off or leaves the country? How will this act now help or support the father's position? Mr. Husband.
Well, I suppose under the Act, previously, if the parties were not married, the father would have a lot of difficulty getting a custody order or a maintenance order. Now, under this Act, it would be easier because the child would have a father. He would be the father of the child. If it is established he's the father of the child, well then he would have all the rights. He will have, I think the Act says, joint guardianship with the wife, with the mother. So he would have an enhanced position to get access to that child and look after that child, get care and responsibility of that child now under the Act, not previously.
Yeah. And I think a big difference, I think, for some fathers, because I know there are a lot of fathers who are raising their children without any contributions from mothers, is it now enables them now to also apply for maintenance. Because previously, if once they have the children, they can apply for maintenance from the mother. The same with the fathers that have to go down to court and make that payment. Now mothers, if they're not being responsible and they're not contributing to the children, they can likewise do the same under this Act.
I know I'll segue into it's June and it's Fatherhood Campaign. And how will this Act impact that campaign, Ms. Connor, for the Office of Gender Affairs?
Well, we really didn't know we were going to have the team ready to come forth, but they worked extremely hard, and we do have a frequently asked question brochure being prepared. So hopefully we'll be able to have some of that information available during Men's Health to distribute.
Okay, thank you for that. And then my final scenario, it seemed to be a very hot topic online when I posted it on my personal page. But it was just saying that a husband was in the hospital and he was dying. His wife was by his side. And she goes, and 2 days later, she meets a woman by his side with 2 small children, 4 and 7. And he discloses to her that this is the woman who he had an affair with. He was unfaithful, and these are his biological children. And shortly after he passes, he leaves no will for her. He leaves no will, and he leaves nothing to say to support the children. And he was the main provider for the children and the other woman. He has a life insurance policy. It's $2.5 million. It automatically goes to the wife. What should the wife do, and how will this Act impact that decision? Anyone? Ms. Forbes.
Anyone became Ms. Forbes. What should the wife do? I mean, we're not here to really give people moral directions. As far as his estate, the portion obviously not in the life insurance policy, she would have no say anyway, as you were saying before. She has to follow the law, and the law would require that estate to be distributed accordingly to all his children, including the 2 that she just found out about. So she doesn't have any say in, like I said, in that aspect of it. As far as the life insurance policy, that's going into another realm, and if he's already dictated that that's where the policy should go, the law doesn't try to impose any further obligation on her to now distribute those funds to the children. If she feels so inclined, she can go ahead. But there's no obligation.
Right, I just want you to say that clearly.
It's a gift the life insurance policy would be read as a gift that was made to her by her husband, you know. So it's not as if she needs now to go ahead and deal with that. He's already made provision for her in that policy. The law comes into place where the father dies not leaving any provision for anybody. So that would be the rest of his estate, whether they had a house together, whether he had 10 acres of land somewhere, that property would be distributed across to his children, all of the children.
So is there any final words on this very hot topic?
No, I think that maybe wives have, I'm going to be controversial, I think wives have overstated the problem. I don't think there's a problem. I think it is a human rights issue, and that the children of a man should all be recognized as his children, and they should no longer be discriminated against because they were born outside of marriage. And I think that's the fundamental beginning point. And if you take that point, you either have to take it or not, but that's the really fundamental point, that whether we want to have a situation where we discriminate between children or want to treat all of a person's children as their own children.
That's fair enough, Ms. Connor.
I think he said it all because it is a human rights issue, and we do want all of the children in the BVI to have equal footing as it regards to their status.
Ms. Forbes?
I think just in wrapping up from a legal standpoint, where property is concerned, and the issue within the community, as I've heard and understood, is that we're concerned about what's going to happen to the man's property after he dies. What we need to realize is that we have control now where we're living to dictate who we're giving what to. The man can go ahead and make a will. Go ahead, draft a will, and decide who you want your property to go to, so that on your death, there's no quibble, no concern about, I should say, sorry, no concern about what is going to happen with this property. Make a will. Make provision for your family, your friends, whomever you dictate. Make a will. That's what I think we should encourage persons within the community to do.
Thank you for that. Again, my guests have been Gender Affairs Coordinator, Ms. Laura Lee Connor, and our legal team, Ms. Kamika Forbes of Forbes Hair and Mr. Jack Husbands of Walkers. We would also like to express a thank you to another member of our legal team who could not be here with us today, Ms. Dion Borland of OIL. For more information on the Status of Children Act 2014, contact the Ministry of Health and Social Development at 468-3701, extension 2282, or the Office of Gender Affairs at 468-3701, extension 3415. To access this report and other government news via web, please visit www.bvi.gov.vg or like us on Facebook at the Government of the Virgin Islands or the Ministry of Health and Social Development, VI. Again, I'm Adriana Salvaral, reporting for the Ministry of Health and Social Development and the Department of Information and Public Relations. Thank you again for tuning in.